Next item of business is our swearing in. People that are going to be talking tonight or are going to be talking on behalf of the claimant and other people in the audience. If you, first of all, I want to make sure you're signed in. Okay, and if not, we will ask that you raise your right hand and just repeat after me that you swear to tell the truth, the whole truth, and nothing but the truth. Okay. And one thing I'm going to ask is that if for the first time you speak for the evening, if you would please make sure that you state your name and where you're and your residence. So Jane, our secretary here, can make sure we have that recorded in our meeting minutes. I know tonight is we have a court reporter in the audience here at the request of claimant here, and the just so we get it on record tonight that the formal record for this meeting will be taken by our zoning secretary. So just make sure we're all on the same page with that. I do have a little opening statement I'm going to give before we get started here to talk a little bit about the zoning appeals and what we do here. This is a brief overview of the functions of the Board of Zoning Appeals. The BZA is a quasi-judicial body, and as such, its role is similar to a judge in a court case. The board will hear evidence and testimony that is factual and will make decisions based on the facts presented. The rules as set forth in the resolution are set forth of this resolution and principles of law. With this being stated, the board's proceedings are relatively informal. But in order to conduct an orderly meeting and allow all parties of interest, and the parties of interest in this case would be any contiguous property owners, we want to give them the opportunity to present the evidence necessary to assist in making the board's decision. Certain procedures will be followed. All interested parties will be sworn in. The applicant will be asked to present his or her evidence, and the board will ask questions. It is the applicant's burden to produce evidence to support the application. The board will not make the applicant's case for them. In order to prepare appropriate meeting minutes, each person who speaks will need to state for the record his or her name and their address. The meeting may be continued by either the applicant or the board. The board must base their decisions on facts and not expressions of concerns or non-factual matters. The actions of the BZA does not become official until 30 days after the date of the meeting that the meeting minutes were approved. So with that said, we have to approve meeting minutes for this meeting within 30 days. Then they will become formal after 30 days after that. Any appeals from the final decisions of the BZA will be made to the Geauga County Common Pleas Court by any party of interest, which would mean the contiguous property owners that are present at this meeting. With that said, I'm going to talk a little bit about this case this evening. This is unique. I've been on the board for 13 years, and we have never had, in my 13 years, somebody who is not the applicant that actually owns the property that the case is about, and especially not at citing zoning inspector error. We have had several instances where the person that has applied for they own the property that the condition is about, they have come before the board with several questions about zoning inspector error. So in this case, it's very unique. Several things. This is in a business. The business in question here is in a business district. The B1 business district in Auburn Township has been in existence since the inception of our zoning resolution in 1948. That is 68 years that this zoning district has existed. In this district, businesses are permitted. The question that the applicant has this evening has to do with zoning inspector errors. We have a document. Our zoning resolution is a living, breathing tool. It has errors in it. It requires interpretation. I would compare it to the U.S. Constitution. It has served a long purpose for a long time. It's a good document. It's not perfect. With that said, it is the zoning inspector's responsibility to understand the document and interpret it, and where there are some areas where there might be some questions about one section overriding another area, or if they contradict each other, it's our zoning inspector's responsibility to interpret that and make a decision. It is not the Board of Zoning Appeals' responsibility. Okay? Just so long as we're all on the same page with what we're talking about this evening. This is all about zoning inspector error. Okay? With that said, there have been numerous complaints filed by the applicant. I believe there was one. I have several of them listed here. I have the document of October 5th, November 10th, and November 30th, 2015. All three of these documents contain bits and pieces of what we're going to be talking about this evening. As the zoning chairman, I have sat down and looked at these, and I've kind of narrowed it down to 15 specific items that we're going to focus on this evening. We're not going to talk about every paragraph of every line item in these documents that I just mentioned. And with that said, let's go through my notes here. Okay, with that said, I'm going to turn this over and let you, as the applicant, make an opening statement, and then the Board of Zoning Appeals will then delve into our specific items that we have that we have been made public, that were as part of a public notice for this meeting this evening. And the way we are going to conduct the meeting, we are going to hear each of these on their individual merits, and we are going to vote as a Board of Zoning Appeals, one at a time on these items. We are not going to vote on them all at once, okay? With that said, I'm going to turn it over to you and let you make your statement.
All right. My name is Jim O'Leary, 6349 Legislative Court, Concord, Ohio. I'm here on behalf of Linda DiBernardi. Let me start out by thanking the board for moving this meeting to February. We were originally scheduled for the second Tuesday in January, and quite frankly, the amount of research that it took to get to today, we needed the extra 30 days, so we very much are appreciative of that. As Chairman indicates, this is an unusual circumstance in that we're talking about a situation where not the homeowner or not the property owner, but a neighbor. Normally you're used to people seeking to do something on their property, it gets denied, and they come in and they look for relief for you. Ms. DiBernardi lives across the street from the property in question, and her situation is unusual in that she's faced with something no one else in the neighborhood is, and that is looking at this property on a daily basis. And so you should have received, did all of the members receive a copy of the complaint that was filed? We make that part of the permanent record. That would be my request. By way of some background, I do have some exhibits, some of which you already have in there. Some of these you may not. But what I wanted to do by way of background is to provide you with, I only have one set of exhibits, so I'm going to hand these to the chairman, and as you desire to pass those around, you're welcome to do so. The first is from the zoning code itself, the intent of what the zoning does, and the fact that there are many different things that affect land use, and when it's all said and done, you have the ability to make decisions related to that land use. I'm also going to hand to you a timeline along with some supporting documents that deal with how we got to where we are. Starting with the property owner incorporating his business, which is the second document that's in that packet. It's difficult. I gave up my exhibits to you, so it's okay. When he incorporated in September 2011 as Nathan's Automotive Detailing LLC, purchased the property at 17680 Auburn Road on November 9, 2012, filed the application for zoning on December 3, 2012 as a residential accessory building. And if you look at that exhibit, you'll see that, and this is missing page 2, yeah, as a residential garage, the applicant and the owner of are the same, and that is Nathan. Is it Tiber or Tiber? Tiber. If I get it wrong, I apologize. No mention of the business in the application. The next part of this is when it is approved on the 7th, there's a permit issued. And there's a zoning permit. We have a picture of that permit that was put on the telephone pole outside the business as it was approved. The approval is for the business and not for the individual who is the applicant. The applicant was the individual homeowner, not the business, according to the application that was on file. What's been provided by way of the actual zoning permit was for the business. Then, upon the approval of the zoning permit, we get the request for a building permit. Also, residential, accessory, detached, the applicant and the owner are the same as an individual, not the business. So from the very beginning here, we've got a situation where it's being presented as a residential situation when it really was a business all along. That's important. One of the things that this causes an issue with the size of this building is septic issues. I don't think I have that in here at this point. I think it's in another exhibit. But this is the building permit. One of the things that we talk about is the fact that this is an incidental building, and what the lot size is versus what percentage of that acreage can be used. We've provided a calculation to show that it's 17%, which as a residential would be greater than the 10%, which is allowable. The driveway, and then again the acreage and what the total square footage is. So that's the first exhibit.
I'm sorry, I missed that. Did you say the lot coverage was 10%?
Residential.
For residential, it's 10%, but in actuality, it covers 17%.
It was applied for as a residential
All right, I
permit.
thought this was a business district.
Well, he applied for it as a residential permit. Residential.
What we're saying is that depending on which one you're going to apply, depends on what standards you're using. He applies it as a residential in every step of the way, and yet this is where we are percentage-wise under residential.
Okay.
We talked about the sewer. The next exhibit that I'd like to give the regulations include that it doesn't relieve the site owner of a responsibility to obtain other necessary permits and approval. Septic is one of those. and through the EPA. So I'm going to give this to you by way of background as it pertains to the standards related to the sewer. Excuse me? Right. Yeah, if it is running as a business, there is no bathroom in this business, and
They're required.
and it's required.
Under building code.
The
What's required under the building code?
The building code requires in that exhibit one bathroom for employees. There's employees that work there, and the building code,
If they don't work on site.
they are there. They are there. They're there in the morning. They're there in the evening. They fill up the trucks for a period of time every single day, and they are there during the day as well. We have photographs of that. So the employees are there. There's an office there as well without a permit. That also would be considered a bedroom under the septic rules.
What, with the garage?
No, the office in the garage.
No, wouldn't.
Septic rules require,
No.
okay, well, septic is telling me that there was a requirement of a bathroom,
You're allowed to put a bathroom in a garage if you choose.
but they don't have septic. They don't have a big enough septic.
No, they don't need to have a commercial septic. If they're not-
EPA
if the-
says they do.
If the public isn't using their bathrooms, if the public does not use their bathrooms, they do not need a commercial septic. That would be like if I went to your house and used your bathroom because I wasn't in your,
The employees are there. But, well, the building code, there's a chart in there of the building code, and it says how many employees you have to have a bathroom. Our point being is, there's not enough septic space there. It's approved for 3 bedrooms.
Do you know how many gallons per day a person is supposed to use for a septic system in Geauga County?
What do you mean by that?
In other words, the system is designed by how many gallons per day the system will
Right.
treat, and it goes by bedrooms,
Right.
because bedrooms include washing dishes, taking showers, going to the bathroom,
Right.
washing clothes.
Right?
So it's 385 or 400 gallons
Right.
per day.
Right.
Okay, so because he has 1 or 2 people use his bathroom, they're not using 400 gallons per day. They're not overtaxing his residential septic
Well,
system.
put it this way, he was supposed to get a permit from the health department. It's not for me to decide. It's for the health.
He was supposed to get a permit?
Yeah, it's
For
in your
what?
For
code.
what?
It's in your code that if you're going to apply for a business, you have to get a septic and an EPA permit. Do we have that code
I
there?
think it says if required.
Pardon me?
I think it says if required.
Yeah, it does say if required.
But what he's doing is discharging car wash water onto the ground.
Well, he was, but that doesn't happen anymore.
He did for a short period of time. Is that correct?
And
No, he's
Correct.
still washing cars there, his own cars.
he can wash his own cars, just
No,
like you can wash
No, wait a
yours.
second, EPA, I called them yesterday, told me it's considered industrial wastewater. It's class 5 injection.
To wash your own car.
It's not his car, they're commercial cars. They're business cars. They'll be out there. That's,
See, this is part of the problem, is that every time we have a conversation about this, the rules change based upon whether you're looking at it as a residential or whether you're looking at it as a business. And that's the problem here, because when you apply under residential, but you're approved as a business, and you're acting as a business, but then you say, well, I want to use the rules as a residential, which is it?
one more thing to add to this. The EPA told me yesterday that Kenston school system is trying to wash their own cars on trucks or school buses on the property, and their permit was denied by the EPA. Same thing here.
That's different because there's commercial degreasers and other chemicals that required by as a bus operator.
That's totally different.
What's the difference? That's not what the agent's telling me. What's the difference between washing their commercial vehicles in the garage? The
If
EPA
every-
agent will resolve this, not me. My point being is he had to get a permit.
Okay, let's move on. Let's keep moving.
All right. It's our feeling, again, this is code under Article 6. It should have gone to zoning commission before it was approved. That's the information related to that. We talk about an accessory building being subordinate to the use of the building. In this case, we're talking about a pole building that's 1,600 square foot compared to a 1,200 square foot house. Certainly is not subordinate. Your code speaks to that very clearly. I'm going to give to you that information. Also included, and it may have been included earlier in your packet, that the KKR case, which involves a similar circumstance with a accessory building where they were storing some equipment in at a bar, and that was disallowed, went through, and the same logic that was used related to the accessory building applies here but was not applied. And so that's part of that exhibit. We also have a picture, I don't know how many of you have seen the actual property, but we are providing a copy of that, as well as some other background information for accessory building purposes.
Okay. First, I'd like to talk a little bit about the KKR situation. KKR is in a residential district. This is in a business district. So there is a difference, and there are other case law that you cite in your complaint that just about all of those, especially the ones that you're citing in Auburn Township, they revolve around people running a business in a residential district. So there's no comparison between the two, ma'am.
May I interject? If you read your code section and it talks about accessory building must be incidental to the primary residence or property, there's no discussion in those or the case law that the use has to be permitted or not permitted. Most cases talk about rather that has to be incidental to the residence, and in this case, it was applied for as a residential permit, accessory building. It has to be the same as the main use. Same thing like KKR. It doesn't matter that it's permitted or not, and actually the judgment says that as well. They agreed. It just has to be related to or incidental is the legal language, and so the case law says exactly the same in Ohio, every single case. There's no requirement that the use be permitted.
The case law that you cite from other counties, I'm not so sure that their zoning laws are the same as ours.
In Ohio, all the accessory building cases are about the same.
About?
They are the same. It's the precedent is it has to be incidental to. It's subordinate.
It's in a residential district.
It doesn't.
Whether you're a village, a township, a
Yes.
city, they're all the same?
Yes.
Oh.
Yes.
Okay. You say so.
I do say so. That's what the judges say, not me. So it has to be related to and incidental and subordinate. In this case, it isn't.
It's not subordinate?
No, it's twice as it's bigger than the house.
Well, I don't know.
1,600 square
Subordinate has more to do with the use rather than a
No, no.
size.
Subordinate means size. By case law, it means the size.
By case law, but we're not talking case law, we're talking zoning law.
The zoning says that the primary use, and you've even said it is a residence. And that's what, and this is a subordinate use to the or the residence is there, okay? That is the main, that is what that property was purchased and is used for. It just so happens there's a business located on it. People are allowed to change their mind, ma'am. They're allowed to change their mind.
Just real quick, if I interject, on the application, it says the existing use lot is residential.
Right.
However, the zoning area it's citing is B1 business.
Right.
So they're claiming they're taking an application to the business district, not R1. This use could be R1 or B1. So he's
That's just citing what
claiming
business, what district he's in, which is B1.
Okay.
What I'm referring
Existing
to
use.
is up here.
Existing use is residential, proposed use is a garage in a B1 district for storage.
But he's not doing that. He never did.
That's just
Yeah.
a small point.
And-
It might be, I don't know, just to bring it to light, that's all.
That was never the intent. In fact, it shows in the permits that it was proposed to be residential, but yet the permit the next day was issued commercial, and then they went to the building department and got a residential permit because they couldn't meet the septic rules. Why else
I
would
don't
you?
know if that's true or not, but
Lou, do the EPA rules intertwine with the building codes for
The EPA, I mean, let me think about that. If you go and apply for a building permit, okay, and you're going to have people in your showroom or people, workers there and stuff like that, like in an office, and it's commercial, then you need a commercial system. Geauga County makes that distinction, not the EPA. Geauga County, when you take your permit to
Right.
Geauga County, this gentleman, just seems to me, he built a garage. He's got a lot that has two uses, a business use and a residential use, and it's legal.
But he doesn't have.
That doesn't mean that every time he wants to do something, he has to run to the health department. First off, if you look at his septic drawing, his system is sitting on chylite soil, which is the best soil. There's only about 3% of Geauga County that's chylite soil. You can put anything in it, and it's going to get filtered out, and it ain't going to hurt nothing. It's the best soil in the county, okay? So there's no way he can tax that system.
But he's required to put on his permit the real use. And if you look at the intervening, hold on a second.
I don't know why they wrote that on the permit. He could have wrote his check out of his business account. And Frank might have just said, okay, I'll put it down in this, because that's who wrote the check, so we'd have...
Historically, he puts down who writes the check.
Right, so if it came out of a business account,
Well,
that's why
then
he's
he
got
should
it on
have
there.
applied for a permit under a commercial so that the Geauga Septic and the EPA could make that decision.
I don't know.
Well, that's what I'm saying.
okay, let's move forward with your
Sure.
exhibits.
Correspondence related to the business use and a copy of your chart. He keeps talking about it being a service, which is not a permitted use under your code, under the chart. So I'll provide that to you. And I have a group of photos. Linda can attest to the fact that these are photos that she
The one important, there's a picture in there on October 5th where they are drawing a substantial amount of water out of the well.
these are the
Okay,
pictures.
okay, excuse me, go ahead.
These are the pictures that are provided. What's the time frame for the pictures that are here?
Between June of 2015 to September. Actually, the top one is October, where they were, the employees were emptying out a large container which goes in each truck. Each truck is drawing, we're estimating 250 gallons in those tanks out of the well, and there's 5 of these trucks, and they are drawing a substantial amount of water every month, which is a threat to my water supply.
How do you figure that? He's got a private water well. You don't even know if he's in the same aquifer.
We have exhibits that we'll be putting on.
You're in the same aquifer as him?
Excuse me?
Are you in the same aquifer as him?
I'm going to give you some exhibits that
Okay.
Well, what we
That'd be a good
have,
one to prove.
will, you need to put that
well,
on book.
here's, basically we went back and we found a study that was done for the board that talked about the water usage. And our concern is that with the amount of trucks that we believe there's, I think, 5, and the amount of water that they're taking out of that location is significantly more than what you would have in a residential use. And that puts adjoining homeowners at risk, because if you draw that water out...
It's a private well. He owns it. He can do anything he wants. If he wants to stick a hose in that well and run it on the street, unless it violates the township law of running the water in the street, he can do it. It's his well. He has a private well permit, and he's allowed to use that water as he sees fit. And when the well goes dry, he's going to have to drill another one. It's simple.
Okay.
My question would be, have you determined, and how have you determined how much water they draw, and how do you determine that it's taxing the well?
The picture of those tanks appears to be 250 gallons. There's 5 trucks. We did an exhibit. They're drawing it 6 days a week.
It sounds like you're making some assumptions, though,
Well,
quite a lot of them.
well,
Linda, how long have you lived there?
25 years. This is a complete eyesore. It started out that all I wanted was blockage. And total uncooperation from all parties. And what happened was we found that these permits were not applied under the truth. And that's my point of this case.
Okay. Please continue with your exhibits.
Okay. As far as minimum lot area, a B1 is 1.5. This is 1.3 acres. There's some other exhibits in there related to that. The parking lot, what the requirements are for that. And the last one is
What's that?
This is the same stuff as what
It was submitted in one separate. They're all numbered.
and then I'm not gonna submit this one. I don't think this is really.
Which one is,
This is the complaint on
oh yeah,
that.
right.
So having said that, you obviously know what the issues are that we have. If you want to go through them one by one, we're certainly willing to answer any questions that you have
Certainly.
related to that.
Okay.
Again, we'd ask that those exhibits be admitted to the record.
Okay, the first item here that we're going to discuss here, so I've identified really 16 items here.
Well, one of them I think we can take off of there, and that's the one relating to the house. We're willing to.
Which one?
The remodel, we're not interested in worrying about that, we're interested in the business.
14A, 16-14A, that's the very last one, right?
Which one?
14A.
This is 14A. Yeah.
So this is being officially withdrawn?
Yes.
Okay. Very good. The first item that we're going to talk about this evening is what we're going to call BZA 16-00A. This is allegations of no enforcement action by the zoning inspector from the October 5th complaint. Okay. In this letter, the complainant wrote a letter identifying specific items very specific items in this letter, and in the response was our zoning inspector reviewed the information and provided a response to each of the items. Okay, most specifically on Frank Kitko's letter of November 13, 2005, which was in your response to your letter of October 5th, there are three specific items, and I think they answer all three of the main complaints that you had. One of them is that they were using this as a facility to wash cars on site. Okay. At that point, I know Mr. Kitko had been monitoring this. He had been talking to the owner of the business, and there was a statement provided by Mr. Kleiber that he will not be performing any on-site services, washing cars or doing any maintenance. I don't think he ever did any maintenance on cars. What he did is he serviced cars, washed them, which was similar to his business. Which, without question, I think everybody on the board here knows that's not permitted. It's not permitted in that type of a district. So the first item here, I feel as though that Frank Kitko, our zoning inspector, has addressed this with the owner of the business. Okay. The second item is parking and landscaping plans. They have been submitted to the zoning here. Mr. Kitko is working with the owner of the business to get them properly installed, and the process has started. There has been a plan submitted. I think our zoning inspector is going to be working with the business owner over the next 6 months or so, once the weather breaks here, to provide more shielding or that is required by our zoning, and not that he's necessarily in non-compliance. If you look at the way that our zoning is written, that there are, you don't have zoning in front of open driveways. A lot of that area is open. There has been some screening placed on the south side of the road in front of the business building itself. So that process is in progress. It might not satisfy everybody to this point, and I know that this is a rather unique piece of property in that you're looking down on it from the south, the northeast, down onto this property. He's only responsible to take care of things at the elevation of his property, not to satisfy the fact that your property sits considerably higher than his.
It's really more or less the road view and the fact that there's a section that requires continuous full blockage, and I just don't feel that what we have there, it's not, I can see everything from the road. I'm not talking about from up high. I can see that, but yet every time we drive by, it's parking cars all over the place, and it just looks, it's a big eyesore. So I think that...
Well, you are allowed to park cars in a business, ma'am.
I think the code says they have to be parked in the building or behind it.
Not during the day. You can park outside.
Okay.
And
Well, my point
the
being-
code does not specifically state that you have to park your vehicles inside.
It says on the side and the rear.
Or a car wash.
Well, my point being is that it's not properly screened. I don't think the little trees that are like this tall screen the road at all. I'm not talking about from the front. I'm talking about the whole thing. Everybody that drives by in Carriage Hill, same thing. They feel the same way. It's just, you can't, it looks bad. So all we're asking for is screening. But I think the rule says continuous, dense screening is the exact words.
I don't think it says a fence.
Dense, I'm sorry, dense.
Oh, dense screening.
One of the options is a fence, and the other option's a mound, is what it says.
Correct.
So that's what I'm trying to say, is it should be black.
You feel that there needs to be more screening than what's there.
Yeah.
Absolutely.
That's really the crux of what started this whole case, is really all I wanted.
Okay.
I mean, that's where it started.
And as I mentioned, our zoning inspector has been working with the property owner. The process has started. Is it complete? I don't have the answer for that. That's our zoning inspector's responsibility to enforce. But I feel the process has started. Okay? That's item number 2. Temporary signage was removed from the property is item number 3. Those items were all addressed, correct?
Most likely, yeah, at this point, yeah, that was a while
Okay,
back, the dumpster.
That's fine. That's what
Agreed.
your allegations were. I just want to make sure that they have been addressed or they're being in the process
Okay.
of being addressed.
Fair enough.
Okay? With that said, we're going to vote on this item here. Okay? But I want to make it clear to the board here how this works. If you're in agreement with the complainant or the complaint, you need to vote yes.
There's one thing we didn't cover, and that's the parking. The parking has to be paved.
We'll get that. That's in a
Okay.
different section.
Oh,
We
is
will
it?
talk about
Okay,
that.
I'm sorry.
We will talk about that.
Okay.
If you wish to deny the complaint, you vote no. Okay? Do I have a motion? Jane, will you take a motion to vote on this?
Which one are we voting on?
First one,
00A.
00A. This is the
okay.
action of non-enforcement by our zoning inspector.
Okay.
There's a motion to grant BZA 16-00A, a complaint filed by complainant Linda D. Bernardi, 17675 Auburn Road, alleging no enforcement action by zoning inspector from October 5th complaint against Nathan and Deanne Tiber and Nathan's Auto Detailing LLC, located at 17680 Auburn Road, Auburn Township, Ohio, in a B1 zoning district. And again, if you're in agreement that there has been no enforcement, vote yes. If you're going to deny the complaint, vote no. We'll take a, did you have a second on that?
I'll second it.
Okay, Mr. Tomsick,
No.
Mr. Freebairn,
No.
Mrs. Feller,
No.
Mr. Peeler,
No.
Mr. Stewart,
No?
motion denied.
Okay, the next item is BZA 16-01A, alleging lack of enforcement of a business meeting the definition of a commercial car wash and or a car repair. This case was our zoning inspector, Mr. Kitco, reviewed the situation, and he made the offer to the business owner. If he wanted to do business as a car wash, he would have to file a zoning request and he would have to hear his case before the Board of Zoning Appeals. The owner of the business said, I don't want that. He says, I am a service business. I do my business off-site. We agree, he is not a car wash business. Okay? He is not a car repair business. He does not meet the criteria of a car repair service garage that would do routine maintenance of service of vehicles as described in the auto repair garage. Both of these allegations do not fit what this business is doing at this in this B1 business district. He is not a car wash. He's a service business.
Well, by definition, a detailing business is a car wash business.
No, that's not true. That is not true.
A car wash.
And first of all, it's not on site. Let's make that clear.
Well,
he
that's
did
what's
do
been-
some business
that's-
on site, but
Some
he is
did a lot.
He did some, and it has been curtailed. Let me say something. There's numerous districts in our township, obviously, for zoning. It is the responsibility of our zoning inspector to enforce them. There are people that take advantage of our zoning resolution and the guidelines. It happens. Our zoning inspector does a very good job at enforcing these things. Yes, things do slip through the cracks. Yes, things do happen. But as they're brought forward to the zoning inspector, he does his due diligence and works with the person that the complaint is against and works to resolve the issue. These things don't resolve themselves overnight, as you probably know, okay? But they do take time to get resolved. These things are being resolved in a timely manner, okay? As far as he did do some on-site work, he was cited for it by our zoning inspector. He acknowledged that he did it, and he also wrote a letter stating that he would not do it anymore. He is an off-site business.
Can we add that the code defines a car wash as simply having equipment in a building? And in this case, that's what we have. We have trucks in the building drawing water. It doesn't say used, it says equipment in the building.
They're doing the business off-site, ma'am.
Yeah, the car wash definition. I mean, if you look at every other car wash in this county that is a car wash, they have to have water recycling, they have to have all this stuff because they're washing hundreds of cars a day. This is not happening on this property. He is going off-site, washing his cars, doing whatever he does for his customers. Now, he was wrong. He's quit doing it. But you can't consider that a commercial car wash. There's no way, shape, or form. You have taken a stretch with the definition. When it says equipped, does that mean if I have a hose in my garage, I'm a commercial car wash? I mean, that's a stretch.
Well, let me leave you with one thing. The EPA yesterday did tell me that washing his trucks is going to be required to be recycled or contained or whatever, so that is a problem, and that's a permit issue.
Well, every business in Geauga County is in violation.
Well, that's fine. In this case, he applied for a residential permit, and really it was a business, and it should have been gone to the health department and those before.
And to be quite honest with you, there are probably other businesses along Auburn Road that probably are in non-compliance with that also. I mean, I don't know that. Like I said, this board does not, we do not go out and inspect, okay?
Okay.
Okay, so with that said, the allegations of enforcement of a business meeting the definition of a car wash or a car repair business. Okay, Jane, would you please read this one and so we can take a vote on it? And I motion to vote.
Motion to grant BZA 16-01, complaint filed by complainant Lindsay Bernardi, 17675 Auburn Road, alleging zoning inspector error of lack of enforcement of a business allegedly meeting the definition of a commercial car wash and/or car repair, Article 2. The business owned by Nathan's Auto Detailing LLC is located at 17680 Auburn Road, Auburn Township, Ohio, in a B1 zoning district. Again, if you're in agreement with the complaint, vote yes. If you're not in agreement with the complaint, vote no. Mrs. Beller?
No.
Mr. Freebaron?
No.
Mr. Peeler?
No.
Mr. Thompson?
No.
Mr. Stewart?
No. Ready for the next one? The next item is BZA 1602A, that no development requiring sewer and water facilities be approved by the zoning inspector prior to approval by the county health department per, please, Article 3.01J, compliance with state and federal regulation, which is 3.05D and 6.07A. This alleges that the business permit should be null and void due to noncompliance with EPA septic laws. First off, the Auburn Township cannot enforce this. This is enforceable by the EPA or the county health department. Okay? We can't go and do this. Now, is the process, it has to be approved prior to approval by the health department? I don't know if that's necessarily true.
Not when it deals with accessory uses. Not when it deals with accessory uses.
So this is an accessory building,
Correct.
so it doesn't require to go to the EPA in order to do this. Now, is there any waste hookups in this accessory building to the septic system? Is there any connections?
I believe there's a bathroom. I don't know. There's a bathroom.
Okay, there's a bathroom.
toilet.
Okay. So this is something that has to be regulated by the EPA. It has to be regulated by the Geauga Health Department to enforce. This is not an Auburn Township issue to enforce. And the other thing is, I have personally no knowledge of discharging. You use the term commercial automotive waste. I don't have any. What do you consider commercial automotive waste?
Not me, but the EPA yesterday told me that washing trucks in the building is considered industrial waste, and it has to be reclaimed.
That's because they could get oil.
Yeah.
If you wash
Well,
in
be
oil.
separated.
Has EPA been out there to talk to him?
The case was transferred from Geauga Septic to EPA for their jurisdiction for commercial septic and well. I talked to them yesterday, and they haven't been there yet, but they're something that they're in the process of doing. But the bottom line is, those permits should have been applied for before the commercial building.
Well, let me understand something. We're talking about the building that he
Any
applied for
business.
in 2012?
Excuse me?
Were we talking about the building that he applied for initially that he called a garage?
Residential garage.
How would Mr. Kitco understand, or how do you infer that this development is requiring sewer and water facilities for a garage? That's what he approved.
Because the permit was issued for a business, Nathan's Automotive Detailing. We have a picture of the actual permit issued the next day. So he did know it was being used for an auto detailing business.
An off-site auto detailing business.
We don't know that. He's washed his cars there. We've got pictures of it.
But that's not what Mr. Kitco was told. I mean, you're suggesting because that this said it was an auto detailing business, he should understand that there's going to be a requirement for sewer and water facilities. I don't think you can make that leap. I think that's not a logical progression.
But Nathan should have applied for the permits if he knew that what he was going to do there.
But how does that reflect upon Mr. Kitco?
Well, Mr. Kitco issued the permit to the business, even though it was applied for as a
But
residential.
it was an off-site service business. That doesn't require...
We don't know that for sure. It doesn't seem to have been.
Well, how would Mr. Kitco know that if you say right now he didn't know, we can't know that?
Well, I'm saying that today we know what it is and it should have been issued. The permit.
So after the fact, we understand that, and he should have known that prior to it happening?
Well, he knows it now.
But how could he have known that? You say he didn't know it then. How could he make a
Well,
determination
we know now
then?
what they're doing. They're washing cars there, so that we need a septic permit.
Wait, time out. They are not washing cars.
We're washing cars.
They
They're
were
washing their corporate trucks there. It's the same thing.
There are
EPA says the same. It is not me.
There are no dates on these photographs or any date stamp whatsoever.
Right.
So
Yeah,
you're
those-
alleging after Mr. Kitco's request to have him stop washing cars that he did not. But these do not support that whatsoever. So I guess hardline proof would assist your plight. However, I don't see any dates on here.
Well, I'm going to testify when those were taken between June of 2015 to September. The reason why the dates have been removed is because when I took them with my camera and transferred them to my phone, there was some dates that did get kind of off. But I took those pictures between June of 2015 and September of 2015.
Okay, when was the cease and desist letter, Frank?
First letter was in October, wasn't it?
Yep.
So it was after September.
So that was,
So
all
he has
those
ceased.
pictures were taken before Mr. Kitco addressed the problem. And the problem doesn't exist anymore. So those pictures are
null and void.
null and void. They're moot.
Okay. Jane, would you please read the complaint so we can vote?
Motion to grant BZA 16-028, a complaint filed by complainant Linda D. Bernardi, 17675 Auburn Road, alleging zoning inspector error in that no development requiring sewer and water facilities be approved by the zoning inspector prior to approval by the county health. 3.01J, compliance with state and federal regulations. 3.05B, 6.07A, complainant alleging the business permit should be null and void due to non-compliance with EPA and septic laws for property located at 17680 Auburn Road, Auburn Township, Ohio, in a B1 zoning district. Motion from you. Second.
A second.
Mr. Peeler,
No.
Mr. Thompson,
No.
Mrs. Beller,
No.
Mr. Freebairn,
No.
Mr. Stewart.
No. The next item is BZA 1603A. Jane, please read it. 1603A.
Alleging the zoning inspector erred by allowing lot coverage to exceed 10%, 4.03G and Schedule 4.03K. In a B1 zoning district.
Okay, for starters, depending on the street, the percentage of lot area covered by main and accessory buildings shall not be greater than given in the Schedule 4.03K. Well, first of all, we're referring to Schedule 4A06, which is for a business district, which references buildings only at 30%. Okay? But it also references, this is the one that references back to the footnote thing. No. Yeah.
No, it's just
Strictly in the B1 district. The building's only 30%. You know,
And he stated that in his letter.
and the building coverages that we have, as far as we can calculate, the B1 is governed by 04068 schedule, which allows up to 30% coverage. To our knowledge, it does not exceed 30%.
By their own admission, it doesn't.
Well, I'm stating that it was applied for as a residential building, and those rules are 10%, and we add all those items in the parking lot, it's 17%. I'm not disputing the business. I'm
It's
saying
in
the
the
permit was
business
issued.
and the residences don't exceed the 30%.
Excuse me?
The businesses and the residents don't exceed the 30%.
Excuse me? Yeah, ma'am.
But it's lot coverage.
I'm saying the permit was issued as a residential storage. So under the residential, 10% is the rule. And you add up all the buildings and the parking lot, it's 17.
The parking lot does not
Doesn't
count.
It counts for residential, not for
Excuse me,
business.
but it does say here, on the schedule you're quoting on 403K, it says one family dwelling, 10%.
Right.
He's not living in the garage. The 10% is his house. Okay? Because he's in a dual-use district, his building is under the 30% rule as an accessory building. And that's allowed to be 30%.
If you count the house at .04 acres, the one garage at .04 acres, the one back outbuilding and the new garage, or sorry, there's two other outbuildings beside the house and the garage, so both .04. It's .1. That's not even 7%, it's not even 10%.
Okay.
Now, that's not including the parking lot, but that's not included. So with all those combined, it's only .1 of a 1.3 acre, which is more stringent than the 1.5 required. So they're still under that 10%.
Brian, for
I
the
went on the
record,
county GIS and did the areas and calculated it.
for the record, the zoning district determines the lot coverage, not the use. And it's a B1 district, and the B1 district is 30% structures only. No parking, it's structures only, and they do not exceed the 10%. So I've calculated it 10 times.
Okay. Jane, would you please read the complaint here?
Motion to grant BZA 16-03A, a complaint filed by complainant Linda D. Menardi, 17675 Auburn Road, alleging the zoning inspector erred by allowing lot coverage to exceed 10%, Schedule 4.03G and Schedule 4.03K for property located at 17680 Auburn Road, Auburn Township, Ohio, in a B1 zoning district. Second.
Second.
Mr. Tomsick?
No.
Mr. Peeler,
No.
Mr. Freebaron,
No.
Mrs.
No.
Mr. Stewart.
No. Okay, the next item is one that our complainant brought up earlier that said that, and I said we would address it in a later time. This is BZA-16-04A. Parking areas are to be paved with concrete and asphalt per 5D2. Let me say this, that this gets into one of those areas in our zoning resolution where it can be interpreted several ways by several different sections of our zoning resolution. Again, we'll look at both of these several different ways, and then we'll make a discussion. We'll have a discussion, and we'll make a decision here. Okay. First off, one of the items cited by the complainant is all parking and loading areas shall have a hard, dust-free surface, and any area with 5 or more spaces shall be constructed with surface of concrete or asphalt. I believe this is the main section that you're citing here, correct? Okay. Five, 5.2. Next, in Article 2 definitions in our zoning resolution, outdoor storage is also defined as an open area on a lot used for parking or storage of equipment, material, or machinery. Okay? Or vehicles for a period of 24 hours or more. It also says that areas devoted to outdoor storage, which does include parking, shall be located on an impervious surface. We go to the definitions in Article 2 of our zoning resolution. The definition of an impervious surface: a surface comprised of material or a combination of materials that repels water and prevents penetration of melt water or from infiltrating soil. These are mainly surfaces constructed of impenetrable materials, and this includes asphalt, concrete, roofing materials, stone, and gravel. So this gets into that gray area in our zoning resolution where it can be interpreted several different ways. It is the interpretation of our zoning inspector based on the numerous options within our own zoning resolution that obviously he has made a determination that gravel meets the definition of an impervious surface. Any questions, comments? And this is an issue that I have even brought up to our zoning commission before, that they need to get this definition squared around.
Well, just to comment, the problem with asphalt and concrete is all it does is take the water off of your property and puts it on somebody else's. And because we're a township and because we just rely on road ditches, we don't have sanitary sewers and such, the more hard surface we put down, the more problems we have. The gravel driveways solve somewhat of that problem because it's a slow saturation process, but they do absorb the soil. It slows down how everything flows off the property, so you don't flood your neighbor or you don't run it out onto Auburn Road, okay, and cause an ice situation in the wintertime in front of your house. So there is some drawbacks to having asphalt. Another thing that it says in the resolution, and I don't know exactly how it's going to, I know I read it, that it's supposed to be adhered to like driveways in the area also. I mean, there's other driveways in this B1 district here that are gravel. I mean, if everybody was asphalted and he was the only one, and then we got a problem. Maybe everybody should be asphalted. But, there's a couple of B1s here that have gravel. There's one or two that are asphalted. On that side of the street, all it's going to do is put the water where it doesn't belong if they hard surface it. You can't put a drain in it because there's no place for the drain to go. So, there's some issues there, like he says.
Questions, comments? Okay, Jamie, please read BZA 1604A so we can take a vote.
Actually making a motion, yeah.
I'll take a motion to vote.
Motion to grant BZA 16-04, complaint filed by complainant Linda B. Bernardi, 17675 Auburn Road, alleging the zoning inspector erred in that parking areas are to be paved with concrete or asphalt 5B2E submitted for property located at 17680 Auburn Road in the B1 zoning district. Mrs. Beller?
No.
Mr. Freebairn?
No.
Mr. Peeler?
Yes.
Mr. Tomsick?
Yes.
Mr. Stewart?
No. The next item, BZA 1605A. Jane, would you please read it?
Alleging lack of enforcement regarding screening along street frontage, the parking lot, dumpsters, and adjacent residential districts 4810.
Okay, this is one, I know that the complainant, this is probably one of your more serious allegations here, correct?
It's an important one
Okay,
for the resale of my house, among some others, but pretty pleasing.
okay. Several things that I noted as I read through the requirements of the landscaping along road frontage, and first of all, our zoning inspector is working with the homeowner or the business owner to try to come to a resolution on this. Now, planting trees, as we know, don't grow overnight. There are other options for screening. I don't think that a mound would do you any good. But there are also rules within our zoning resolution that aren't going to really protect a whole lot from what you see on the road. For example, all the driveways in the front, they don't require any type of screening. There's a lot of driveway in the front of that building. He has made an attempt to put something in front of there. There has been some screening attempted to shield itself from the house to the south. So, they want to see a continuous visual screen within 3 years of installation, not less than 6 feet tall from a natural grade. That is the one thing that kind of stuck out to me. Perhaps more trees are required to comply with what's being alleged here. Again, the Board of Zoning Appeals does not enforce this. It's our zoning inspector's responsibility. I do know that our zoning inspector, has worked with the owner, the property owner, to come up with a solution here. It's not going to get solved in the middle of the wintertime in February. However, it does. If this is a legitimate complaint, that if you as the contiguous property owner, you have a right to work and expect some results here, no doubt about it. And I think that that's something that our zoning inspector has on his agenda here, to work with you and with the business owner here to try to come up with a situation that everybody can agree to, and it solves your problem and it takes care of his problem. Okay? Is Any questions, comments here on this?
I just think we really need to do our best due diligence effort on this one
I would agree.
to the utmost.
Yeah.
It, just by way of explanation, I know this seems tedious for all 15 of these items, but, you know, our feeling was, when we brought this to Frank's attention, and when she got the letter, you know, to preserve the administrative appeal, we had to bring all these things. They may seem like they're, you know, resolved now, but at the time that they were raised, and the reason why we filed this appeal, I just want you to understand that maybe some of these things have been resolved, at least, you know, in some respects. But, you know, the reason why these are all in front of you today is at the time that we got that letter, we had to preserve our right to appeal on all those items.
Absolutely, and you're on record for that.
And let me say one thing too. From the beginning, I have tried very hard to work with a number of people on this issue. This is the whole crux of the matter. I tried personally. I spent thousands of dollars of my own money blocking this, and I get no response on the other end. And it's very bothersome.
When you say on the other end, who are you referring
Between
to?
both zoning and the property owner.
Okay.
I tried to resolve it personally
Okay.
without this. At times, I was told to bring this case on. In other words, instead of trying to work with me, because that's what I wanted, I didn't want to have to do this. I just wanted some blockage so we'd all be happy, and I got no response other than bring it on. And so here we are. And that's my point, and also I know that the people in Carriage Hill feel the same way. They may not be here today, but I get a lot of questions, what's going on over there?
Ma'am, I want to stop you. I don't want to hear hearsay about what you suggest to
Okay.
people
Sure.
that Carriage Hill might
Sure.
have to say about
All
this
right.
issue. You've done it before. Please
Okay.
don't do it again.
Of course.
Thank you.
So I'm going to just state that from my perspective, if this could have been resolved, I asked many times when I came in here to the zoning board, can we just get some trees up? I must have said it 10 times. And I got laughed at, you name it. So that's why we're here.
And that's fine, and that's how the process works, ma'am. And Mr. Peeler made a great comment here. This is an important issue. I realize that. I think this board realizes that. And I hope the property owner realizes this also, that, you know, you have to be, number one, you have to be compliant. Number two, you have to be courteous to the people that are your adjacent property owners. And there's no doubt about that. I agree 100% that this is probably the top issue that needs to be addressed here.
And while this started, there were dumpsters with garbage hanging out of them, for, 10. So you
We
can
saw the pictures of
you
that.
understand.
Yes,
This is where I'm coming from.
But that was all taken care of, ma'am. I mean,
Yes, but not really. It's not really. It's still, you're driving by looking at it, you're seeing people out there, and it's not a major thing.
Okay. But it is a business district, ma'am. I mean,
All right.
you moved into a residential district across from a business. There could be
A bank with a
a
drive-through,
banquet facility across the street from you. I mean,
a nursing home.
there are. This has been there since 1948.
Brian, if I may say something, I have never refused to work with this lady or with the property owner. She has to understand, as you have stated, and for the record I will state this, I have talked to Nathan, but it takes time. And just because you come in here on a Friday and lay something down on the desk and want me to, it takes a week or two to get go through my due diligence and then follow up with the property owner. So don't say that we didn't address it, because we did address it. It may have taken some time. You may not be happy with the time frame, but we are addressing it. And as I told you and your attorney when you sat with me, myself and my attorney, Bridie, that this is an ongoing thing with the screening and will be addressed more in the spring. So don't say that we gave you a cold shoulder, because we did not.
Okay, but that's this is not.
Right.
I understand where you're coming from, Frank. But with that said, I just would like to vote on this here. We could all agree that this is a top priority that needs to be addressed.
the property owner wanted to say something.
Okay, excuse me. Go ahead. Please state your name and your address, please.
Nathan Tiber, 17680 Auburn Road. What is considered tall enough trees for.
Well, see, there, that's a gray area too, because if you look, I was just reading it, and because in the B1 district, they want 3 shade trees for every 100 linear foot of frontage. The trees have to be a minimum of 6 foot tall with a trunk of at least 2 inches. 20 shrubs for every 100 feet of lineage, of 100 linear feet of frontage, or a fraction thereof, not including drive entrances. Now, if you turn the page and you go to screening of parking lots along public roads, it says wherever parking areas consisting of 5 or more spaces are located, and it will be visible from the public roads, screening shall be provided and maintained between the parking area and the road right-of-way. Such screening shall have a minimum height of 3 feet and shall be placed along the perimeter of the parking area to effectively obscure the minimum of 50% of the view of the parking area. So, I mean, there's a 1.5 dozen ways you're going to go. The basic problem is you're so high, I don't know what he can do there to really block your view. Unless you want to
Usually
from the road area.
It's the drive-by issue, because to sell my house, I realize in the bedrooms, what can I do?
Well, his plan that he submitted for the drive-by issue with the small evergreen shrubs close together will probably be the most effective screening, I would think.
Was there an island there? And is there an island there
So
currently?
there is an island area,
Yeah.
and there's approximately 3 feet depth that is behind the area that you would be allowed to plant shrubs within a certain feetage off of the center line of the road.
Mm-hmm.
And it's approximately about 12 to 15 feet long, I would say. And otherwise, then it drops off into the driveway and there's rocks around there. And so there's only a small area where we're allowed to plant stuff. And I want to state that as soon as Frank has contacted me about any of these issues, I have immediately addressed them. As far as the planting, I went to Petiti's within a week or two of him talking to me and bought the biggest ones that they saw, which is 5 to 6 feet there. It says right on the tags that I bought. And then on top of that, I also built mounds to plant them in. Instead of digging them into the natural grade of our soil going down, I built a 2-foot mound, so the ball is actually sitting on top of the natural grade, and then the dirt is built up around it to try and make them higher. So with that being said, I mean, I really have tried, and every time Frank's come to me, I've made every attempt to do everything that he has asked me to do. The first that she states that she has tried to work with us about this, but the first I ever heard about this whole incident, about her being even upset, because I actually have been I thought we had a great relationship prior to this. It was me being out in the front yard and her walking over and stating to me that she was filing a lawsuit against me and I will be served papers within weeks. And that was the first I heard about this. And this was back before she even filed her first complaint to the zoning here. And I really have tried very hard to do whatever. And I will continue to do that. Obviously, I want my property to look nice. I've made an attempt in every way possible to do whatever I could. You know, I did get rid of the dumpster. It cost me more money to have, little toters sitting around. I could have, built a fence around the dumpster, which I think would have looked even gaudier than, than getting rid of it completely. I put up those trees. I planted some trees on the side. Like I said, they are 5 to 6 feet, and they're going to take some time to get bigger. If I squashed more trees in that small area, most likely some of them would die because of them being too close together. I mean, so I want you to know that I have tried, and I disagree with her saying that we have not been willing to work with her, because I really have done everything I can do to please my neighbor.
Okay. Well, okay. With that said, obviously there's more work to be done here. There has to be more collaboration between the owner, the adjacent property owner, and the zoning inspector. Okay? With that said, Jane, would you please read this so we can take a vote and move on to the next 10 items?
Motion Fran BZA 16-05, alleged lack of enforcement regarding screening along street frontage, the parking lot, dumpsters, and adjacent residential districts 4, 8, 10. Mr. Tomsick,
No.
Mr. Peeler,
No.
Mr. Freebairn,
No.
Mrs. Beller,
No.
Mr. Stewart.
No. The next item is BZA 160A. Jane, will you please read it? 06A.
Alleging lack of enforcement regarding bay doors can exceed 10 feet in height, 5.03 K2C.
Okay, the section of our zoning resolution that's being references to a car wash. Okay? First of all, we have already determined through our votes this evening that this is not a commercial car wash. So, with that said, that this specific section of our zoning resolution does not apply to the request that's being made here, or the allegation. Are there any other comments, questions from the board?
Motion.
Jane, would you please read it and we'll motion?
Okay. Motion on the floor to grant BZA 16-06 alleging lack of enforcement regarding bay doors cannot exceed 10 feet in height, 5.03 K2C. Mr. Tomsick.
No.
Mr. Peeler.
No.
Mr. Freebairn.
No.
Mrs. Beller.
No.
Mr. Stewart.
No. Next item, BZA 1607A, alleged lack of enforcement regarding storage of supplies. This is citing, Jane, will you please read it? Make it formal. 07A, just read.
BZA 16-07A alleging lack of enforcement regarding the storage of supplies, 5.03 K2C.
Okay, this is very similar to the previous one that we heard. This cites that this is a car wash, a commercial car wash. We have determined through the board here that we do not believe it's a commercial car wash. So I would like to, motion for a vote.
Motion to grant BZA 16-07 alleging lack of enforcement regarding storage of supplies, 15.03 K2C. Mrs. Beller?
No.
Mr. Freebairn?
No.
Mr. Peeler?
No.
Mr. Tomsick?
No.
Mr. Stewart?
No. Next item, BZA 1608A. Jane, will you please
Alleging lack
read
of
it?
enforcement regarding dumpster locations, 5.03 K2D.
Okay, with this situation, this again reads from a commercial car wash section from our zoning resolution, and we've already determined this is not a commercial car wash, plus the dumpster was removed at the request, at the direction of, or it voluntarily removed by the property owner. I motion to, Jane, please
Second.
read it.
Second it.
Motion to grant BZA 16-08A alleging lack of enforcement regarding dumpster locations, 5.03 K2D. Mrs. Beller?
No.
Mr. Freebairn?
No.
Mr. Peeler?
No.
Mr. Tomsick?
No.
Mr. Stewart?
No. Next item,
16-09A alleging lack of enforcement by the zoning inspector has effectively issued a variance by allowing a car wash No section of the resolution was cited.
First of all, this is a business district. It is a business that has been determined by our zoning inspector to be, and it is a permitted use in this business district to have a general, what's the term they use, a general
Service.
general service business. We have already established that this is not a car wash. The one item here is the accessory building is incidental to the use of the primary building. In this case, the accessory building, we consider this a subordinate use of the building, the use of which is clearly incidental to the use of the principal building structure.
Or none.
We're on 9.
Well, no, no.
Yes.
Okay. Open to reading for 10.
You're reading up to 10.
Yeah, you're reading for 10.
Okay.
Ryan is addressing.
No, I don't think there's any.
This is the definition.
Okay.
This is it, talking about,
No variance required.
there's no variances required, because we've established that
Okay.
this is,
Right.
Not-
Okay.
motion?
Second,
I'll second.
motion to grant BZA 16-09A alleging the lack of enforcement by the zoning inspector has effectively issued a variance by allowing a car wash. Mrs. Beller?
No.
Mr. Freeberry?
No.
Mr. Peeler?
No.
Mr. Thompson?
No.
Mr. Stewart?
No. Next item,
BZA 16-10A alleging error in applying the accessory use standards for building parking, 5.02, 2.02, 4.03B.
okay, BZA Article 5.02A defines the location of an accessory building. The accessory building, this accessory building is in compliance. Article 2-02, subordinate use of the accessory building that is clearly incidental to the use of the building. The residence is the main principal use for this piece of property. Article 4.03B defines accessory uses as a subordinate building when it is clearly incidental and on the same lot as the principal building of use, which the principal building is a residence. And in this situation, the definition of subordinate is of less important or secondary. So the alleged that they're applying the accessory use as a standard building, I think we've already determined that that is incorrect. We feel that this is a subordinate structure to the site. The main use is a residence.
I understand. Your understanding was because it was bigger, it wasn't subordinate.
It's not incidental or subordinate or customary.
Okay.
Once again, the permit being issued to the residents, case law says that it has to be related to the residents, just like KKR. That was the determination in KKR as well, that it had to be the same use as the patio bar. Same logic.
Different zoning district though.
Once again, use is not a standard on that particular section, nor in the case law.
Well, I'm just looking at the definition of subordinate. It says of less important secondary.
Is that in the code?
It's out of a dictionary, I think.
Well, case law says subordinate, okay, I'm going to Ohio case law, subordinate meaning smaller. And basically.
Secondary, less important.
Right. Once again, it's not a matter of permitted use, and even your code section does not state that as well. And the same thing on KKR, it was decided that it just wasn't related.
So I'm not so sure that was the case, was it? KKR was totally different, wasn't it?
Well,
Any
the
issues on
district-
KKR.
KKR was it's a residential district, and you have a commercial building, and with a non-conformity, and the specific purpose of that structure when it was applied for and built was to serve solely to the bar,
Right. It was the storage for the bar.
exclusively.
Right. Okay. So we're talking apples and oranges here.
We have a motion?
I'll second it.
Motion?
Motion to grant BZA 16-10A alleging error in applying the accessory use standards for building parking 5.02, 2.02, 4.03B. Mrs. Beller?
Yeah.
It's your tax dollars.
Mr. Freebaron?
No.
Mr. Peeler?
No.
Mr. Tomsick?
No.
Mr. Stewart?
No.
Next is motion. BZA 16-11A alleging error in allowing a residence to be connected to a business in a B1 district. Article 4A, column 1B1A1.
The schedule of uses for a business and industrial district is scheduled 4A05. B1 general business district has a footnote at the bottom. Footnote for B1 district reads, R1 district permitted main and conditional uses apply to the B1 district. You go to the R1, the
R1?
R1.
These are on a different page. These are uses.
This is the 4.03 residential. Let's see. And in the R1, let's see here. Here,
Yeah,
family dwellings, minimum.
well, that's what's permitted there.
Yes, permitted, but it's going to R1 district.
And then go into the definition.
Yes, then we go into the, hang on one second, let's make sure we have this right here. Residential districts, one family dwellings, let's see. Public facilities, conditional uses. We go into the here. In the general business, yes. One or more of the following uses with, and this applies to the residential in Article R4, the residential building regulations. It does allow for general business for one or more of the following uses with or without a dwelling unit unless otherwise provided by the resolution. So with that said, you are allowed to have a separate building with or without a dwelling, tying it back to the Article 4 of the resolution.
The chart also requires 1.5 acres for this type of a business. And getting into the non-conforming issue, the law in 1971, we provided you with an exhibit. I believe it was 1971. There was no requirement of any acreage for a business. In 1984, it went to 1.5. And in 1990, it also was 1.5.
Where did it go to 1.5?
There was no acreage requirement for a business in 71.
Okay.
The law of non-conforming use says that you have to have an established use on that business to be grandfathered in. And between that period of time, there has never been a business there. Therefore, there cannot be grandfathered in. So that it doesn't meet the requirement.
You're saying by 0.2 of an acre.
That's about 10,000 square feet. And the reason why this is important is for septic and the well issues, the density issues. That's why it's important.
Okay.
I guess I don't understand what she said. You?
Do you want me to
Am I the only
rephrase?
dumb one here?
Justin.
Section 3, I believe it's 3.03, non-conforming, meaning there was a period of time where you didn't have to have any acreage to have a business. Then it changed.
In our code.
Right.
What's
Chapter
verse?
It's exhibits for the 1971, 1980, and
It's
1984 code.
one of the exhibits you pass out.
Yes.
Okay.
Oh, okay.
Can you cite which exhibit it is?
It is,
in front of you, I think, still.
I can tell you.
This is all mine.
Probably
Yeah,
8 or 9. It's probably 8 or 9.
We're all here.
Oh, they're down here.
Where these little-
You're over here.
It's exhibit number, should be 9.
I think we got exhibit 9.
So my point being, right now, they're enough. The acreage isn't enough.
Okay, I
And
just
to be
want to...
grandfathered in under Ohio law, Ohio Revised Code requires section 519.19 that all townships have to have the non-conforming rule in that if it's not used for 2 years, you have to now go under the new rule.
Okay, well, she withdrew the non-conforming thing.
That was on the residents only. That's on the residents only.
There's nothing on this lot that's not conforming, is there?
When you don't have the acreage, it becomes non-conforming.
Here again, let me state, you have the following nonconformities. Let's get this clear. You have legal non-conforming lots of record, which is what both Nathan and Linda have. Then you have non-conforming uses, which neither one of them have. The uses on Nathan's property are both permitted uses. Linda's property, permitted use residential, but she has a non-conforming legal non-conforming lot of record, which is what Nathan has. It's not a use issue, it's a lot coverage that makes it non-conforming. The uses are conforming, and they always have
Which
been
allows you to
conforming.
develop the lot for
Right.
the district.
And that district was created in 1948 when zoning began. And the lot has not changed.
2 things. The law changed between 84, I believe, 71 and 84, somewhere in there. There was a law-
ORC or Auburn Township zoning law?
Excuse me?
ORC or Auburn Township zoning law?
Auburn went from nothing to 1.5. The Ohio Revised Code overrides that
and says you have to have that use within 2 years to grandfathered in. It was lost at that point in time. So when the lot of record rule came in around 1990, it came in because the residential rules changed to 3.3 acres for residential. This was already lost. Under Ohio Revised Code, which overrides the whole.
You're saying
The use was never lost, but the acreage compliance issue is a legal non-conforming lot. There's still a lot of development under Ohio Revised Code.
If you look at the lot of record rule, the last clause says it has to meet all the other standards, and we are stating that it doesn't as part of our case at the moment, which you may or may not agree.
Say that again?
She's indicating that they haven't met all of the other standards. What are they?
Once again, we're stating that the building is getting back to accessory building and not incidental. All the things we've already.
Okay,
Yeah,
so
you
we've already
disagree with
talked.
us, but for the record, we're saying that it doesn't, or going forward, that it doesn't meet any of those standards. Also, if you read the case, there's case law on this, specifically Auburn Glen, which is right in this area, and that case was right about the time where the 3-point acreage changed for residential, and they did not plot the land yet, and the courts cited the 3 precedent cases, one being Juilliard, second being Tort, and those cases say Ohio Supreme Court says you have to have an existing use on that property to be grandfathered in, and that's the precedent-setting law in Ohio.
To grandfather a use?
To grandfather, this is considered a use because it was lost before you brought in the lot of record rule, which
Right.
came in the 1990s.
No.
So you cannot go back and retroactively
Well,
apply.
I guess I can't get my arms
We're
around
still
it.
use and we're still acreage requirement.
It's a timing of the law change issue. You
So-
can't retroactively apply the lot of record when it's already been not met.
So that means they just took away the man's property, or his
Correct.
ability to
The
use
courts
his
say
property.
it's not. What it is it runs with the land. It doesn't run with the owner, and it doesn't start over again after 2 years. It started back in the 80s. Nobody was using it for business, and that runs with the land. It doesn't run with the property owner.
So that means that zoning doesn't mean anything, even though we have...
On this particular issue, that's what the Ohio Supreme Court has said, and you have to have a substantial investment in that property to claim that defense. And in this case, you wouldn't have that.
substantial to one and substantial to
Well,
another.
this is what the court's saying.
Okay, I know. I love the court.
No.
And you stop the use for 2 years, you could not go back to it. Okay, well, I do. All right.
Okay. This is interesting. There's some interesting pieces to this. I think that obviously
This
are worthy of looking at.
I was going to suggest that perhaps we can provide some additional information on this. It's a very hard concept to understand.
It is.
It really is. It's very hard, even for lawyers. But the bottom line is there's a difference between the use regulation and the lot of record that Frank and I disagree over, and I did the research on it and found that it was lost right around the 80s, and the courts do not allow you to go back and start over again, and it runs with the land. So the fact the lot of record rule came in around 1990 is somewhat irrelevant. Actually, it is irrelevant.
How much is this lot off?
Yeah.
Point one, it's 0.3, its requirement's 1.5, it's 1.3.
The 2/10. 2/10 of an acre?
With that said,
That's some new information we all need to absorb.
Right, we'll take a vote on this right here. There is probably more, there could potentially be more behind this, we're not. So, with that said, Jane, will you please read this so we can take a vote?
Grant BZA 16-11A alleging error in allowing the residents to be connected to a business in a B1 district. Article 4A, column 1, B1A1. Second.
Second.
Mr. Thompson.
No.
Mr. Peeler.
No.
Mr. Freeburn.
No.
Mrs. Beller.
No.
Mr. Stewart.
No. The next item, Jane, please read it.
BZA 16-12A alleging zoning inspector error in allowing two uses on the same parcel.
I think this goes back to
Business general again.
the same application as the previous. The other had to do with the lot use. This is two items on the same lot.
Basically, the allegation here is septic. It is not large enough, again, with 1.5 requirement to meet two uses for septic purposes. Not that I know that, but it should have been addressed with the health department, and the health department has turned it over to the EPA as jurisdiction for commercial septic. So,
I have to wait to see what the EPA says then.
right.
So with that said, Jane, please.
Making the motion. Second.
I'll second.
To grant BZA 16-12A alleging zoning inspector error in allowing two uses on the same parcel. Mrs. Beller?
No.
Mr. Freeburn?
No.
Mr. Peeler?
No.
Mr. Thompson?
No.
Mr. Stewart?
No.
BZA 16-13A alleging zoning inspector error by wrongfully deciding that an accessory building can be allowed in a B1 district if it meets the zoning district list of uses. And there was no article cited on this, that I recall.
Under our regulations here, under business and industrial district regulations, B1, R1 district permitted main and conditional uses again apply to this application. So if we're going to be applying the same scenarios that we have for the last two, they would apply to this scenario also.
Again, we talked about this one before, but the use is not relevant to accessory.
We've all
Right.
already determined
Right.
our decision.
Well, I'm putting
was-
on the record, so.
Okay.
Do a motion.
Second.
Motion to grant BZA 16-13A alleging zoning inspector error by wrongfully deciding that an accessory building can be allowed in a B1 district if it meets the zoning district list of uses. Mrs. Beller?
No.
Mr. Freeburn?
No.
Mr. Peeler?
No.
Mr. Thompson?
No.
Mr. Stewart?
No. Our next item is BZA 1614A. This is the item I believe that has been withdrawn.
Yes.
Okay.
Withdraw?
Yes.
Hey, Jane, would you please read the next one?
BZA 16-15A alleging lack of enforcement regarding storage or equipment and vehicles are required to be located in the enclosed building. Outdoor storage definition, B1.
Oh,
15A is, alleging lack of enforcement regarding storage or equipment in vehicles are required to be located in the enclosed building.
Okay, the parking and loading facilities supplemental regulation for the B1 district states that the owner of the lot or any parking or loading facility shall be responsible for maintenance in good condition without hold, dust, or the parking of any unlicensed or disabled vehicles on any lot or loading facility for 15 days is not permitted. That's one item. So, and I don't believe any of your vehicles are not operational or without license. Is that correct?
Correct.
Okay, the next item, outdoor storage is again an open area on a lot used for parking or storage of equipment, materials, machinery, or vehicles for a period of 24 hours or more. I believe that is permitted. I don't believe you cited that they had any section of the zoning resolution that they have to be indoors.
Are we reading Article 3, there shall be parked on the side and rear lots? Article 3B, outdoor storage?
Yeah, that's where the number is.
Yeah, outdoor
So like I said, nothing was cited on
Okay,
your.
that's what I'm saying.
Okay. Which one are you citing again?
I just lost it. 3B3.
B3.
Oh, 3.02, wait a minute, yeah, 3.02,
Okay.
9,
B3.
B3.
And there might, I think there's a second section as well.
No, it's not conforming, this is in my book.
Sections.
There's two sections on it.
Here.
Say,
No, three.
I don't see it's 3.
Vehicles, number 10.
I think
I don't know which one.
This one.
It says, unless otherwise provided, vehicles such as automobiles, boats, campers shall be parked on side and rear yards.
which section again are you citing?
3.02 B3.
B3.
3.02 B3.
I see B, other standards, is that what we're, that, because
3.02
as we're looking at different books, I don't see a B3 and
3.02 is maintenance
3.02.
standards.
Yeah.
Let me, provide you my copy. Yeah,
Shall
no,
only be parked inside or rear yards. Unlicensed or disabled vehicles shall be stored only in enclosed buildings on a lot.
that says vehicles, autos shall be parked on the side and the rear. What is that?
Can I see?
Is that
What's the revision
is that
date?
for a car wash?
No.
I don't know.
You know,
Let's say, they have to be parked on the side or the rear.
Unless otherwise provided,
That's the statement right here. Right here.
side and rear yards.
Where's the front person? Oh, it's different.
They're
I don't know
different.
why it's different.
Unless otherwise provided for this reason. Vehicles such as automobiles, boats, campers, and trucks shall only be parked inside and rear yards. Unlicensed, disabled motor vehicles shall be stored only in enclosed buildings. And I think that ties back to what I was saying earlier about unlicensed vehicles can only be, or disabled, are prohibited over 15 days. They want them out of sight.
Side and rear.
I don't have anything to cite that they have to be stored inside a building.
The side or the rear. They have to be outside or the rear, and in this case, they are generally in the front.
Right, side and rear are permitted.
Agreed.
Okay?
And how does he have his parking drawn up? Is it on the side?
On the side, he does park his one van in the front yard, in front of the building.
In front of the building?
For a period of time, they were all in the front.
But in the last month and a half, it's been one vehicle in the front, one van. One van.
Is that parking at days in or loading supplies on the road?
Right, I mean, there's times when there's more than one van, but one van, if you were to drive by there right now tonight or overnight, there'll be one van parked there.
Is that due to your enforcement?
Well, no, I mean, I did ask him,
Storage.
Okay.
you know, and he may have not,
Considered outdoor storage.
right, he parks one van there. He does, his employees do park on the side or rear, along the side, the south side is where his parking is drawn up and shown on the site plan.
Okay.
And he may have one parking space that exceeds the front of the building, but it is on the side of the property. And it probably does exceed the front line, but very seldom does anybody park there. And for the record, the last 3 weeks, there's never been more than 3 vehicles parked there. On that is at 7 o'clock, 10 o'clock, 11 o'clock, 2 o'clock in the afternoon. There's never been more than 3 vehicles.
Well, again, this goes back to there's some items in our zoning resolution that can be interpreted different ways.
Right, the outdoor storage.
Yeah, outdoor storage is clearly permitted, it doesn't define any particular place. It's an open area on a lot used for parking of storage or equipment, machinery, materials for a period of 24 hours or more. Again, you look at the other section that was cited here on vehicles such as automobiles, boats, campers shall be only parked in the side or the rear. This is one of those gray areas where you get into where there are two definitions here. It's up to our zoning inspector here to enforce these rules. It's not the board here responsibility here to enforce the rules, but I have to go by what our zoning inspector, the way he's handling it. If there's problems with cars being parked out front, or if that's something that's in violation, that's something that our zoning inspector is going to have to take up. Nathan?
I will say that I would be telling the truth if I said there's abnormal amount of vehicles at my house, and I can be honest and tell you that I have over 36 aunts and uncles, over 100 first cousins. I have an extremely large family, and we love entertaining. We have people over all the time. So during the middle of the day, my mom might stop over, her mom stops over, grandma stops over, the babysitter's there, I pull in the driveway, Deanna pulls in the driveway, because our jobs are always coming and going, and all of a sudden we have 5 or 6 vehicles of our own in the driveway. That's not even including anything with work. So there are a lot of vehicles that come in our driveway, whether there was a business there or not. We do have a lot of vehicles coming in now.
May I state that it's only the business vehicles that we're concerned about, not the personal. We realize that. That's not a problem.
No, I would assume
It's really the screening and the trucks and the business issues that are in here.
I mean, let me ask this, Nathan, you do park a van out front, do you? Or
We do have one van parked out front, yes.
Is there a reason why that can't be parked around the side, or?
No, we can work on that and have it parked more along the side of the building. Sometimes at the end of the day, especially when it's nice out, in the wintertime we're almost always parked inside, and sometimes at the end of the day they do park the vehicles outside, and not put them inside the garage. But it's definitely something we can be more conscious of for sure.
Nathan, how long is the building from the front where the garage doors are at to the back?
It is, the building is 40 by 40, is that what
Okay, so if you were to either, just in the spirit of getting along, and I guess you work with Frank and your adjacent property owner, either a fence off that corner or a peninsula, that therefore you could tuck those vans or cars back around the back side. No one would ever see them, or be the wiser. And it really, I think, improved the situation there. we're not pushing that, but that's up to you and Frank, and if you guys work that, I think it'd be a good idea, maybe. I don't know.
I think this is
Working with
similar
Frank.
to the issue with the screening and the landscaping.
Yes.
That, there's obviously some work that needs to be done here. Not saying you're not a good neighbor, not saying that. I'm just saying that I think that this is where this collaboration between you and the complainant and Frank have to get together, and we need to see some consistent enforcement of this.
I have, over the past 2 years, I have, each year I've ordered 2 more loads of asphalt grindings to continuously try and add more on the side of the building and along the back of it. And so we have, the first load, was enough to get us all the way down the side of the building, and we have tried to tuck the employee parking along the side of the property line and everything, so it is not as out in the open. And then the load that I actually got over the summertime, this is before any of this had been brought up actually, brought me maybe like all farther back on the property and probably about 10 feet behind the building as well. So it is something that we are continuously doing to continue expanding that, so we can, get more vehicles behind the building as well to help with that.
Okay, with that said, Jane, I motion to take a vote on this.
Second.
Mrs. Beller?
No.
Mr. Feburary?
No.
Mr. Peeler?
No.
Mr. Thompson?
No.
Mr. Stewart?
No.
And that was for BZA 16-15A.
Correct.
Yes.
All right, for the moment we've all been waiting for here, we have our last item here. This is BZA 1616A. Jane, would you please read it?
Alleging error 6.01A1A requires an application to be reviewed by zoning commission before action can be taken by zoning inspector.
Okay. This is pretty interesting. And the reason is that it's citing the 2 specific items, and this too can be interpreted several different ways. To read the first item, which is 0601A, which is item 2. Let's make sure we got this right here. 'Cause I'm referring back to 6.01A. 1A. 6.01.
A, and then 1.
6.03A.
Okay, in this case,
Brian,
what's that?
6.03A.
This is listing 6.01.
And then go to 6.03A.
Correct.
Oh, that's the second one.
Yes. The first one is 6.06.
Yes, this one here.
And right here. This one right here. Isn't that the same one as this? Proposed permitted use in a flood-prone area or permitted main or accessories in a B1 district shall be acted on by the commission prior to action by the zoning inspector. This also references back to 6.02A and 6.03A. the states in 6.02A says within 5 working days of filing date of certain application, the following referrals must be made by the zoning inspector. I think that goes back to, ties back to this item here, doesn't it? All applications proposing permitted main use in a flood zone area or permitted main accessory use, B or 1 districts, conditional uses, except queries, or amendments shall be referred to the commission, see 6.03A. And if we go to 6.03A, 6.03A kind of sums this up. It says the commission shall, and I want to emphasize that, shall assist the zoning inspector and the board in their consideration of certain zoning permits. Not all, of certain zoning permits. In the conditional use application, if it's referred by the zoning inspector. In this case, it was not referred to by our zoning inspector. So there was not it fit the criteria that it didn't fit all cases. So he was not required to submit it to the zoning commission. It's his interpretation and reference that he's allowed to if he wants to. In this case, our zoning inspector did not.
Be great. Thank you.
Okay, with that, Jane, can we please reread this so
Do
we
we
can...
have a motion?
I'll motion.
Second.
Second.
To grant BZA 16-16A alleging error 6.01A1A requires an application to be reviewed by the zoning commission before action can be taken by the zoning inspector. Mrs. Miller?
No.
Mr. Feburary?
No.
Mr. Peeler?
No.
Mr. Thompson?
No.
Mr. Stewart?
No. Okay, that concludes the items that we had of new business today. Do we have any housekeeping tonight, Jane, that we need to take care of? We don't have any meeting sign-off or documentation. With that said, our next meeting is scheduled for March 8th to approve the meeting minutes from tonight's meeting. Okay? If there are any questions, that you as a complainant have, you're more than welcome to talk to our zoning officer. But in the meantime, we have 30 days to approve these meeting minutes, and more than welcome to join us for approving the meeting minutes next month.
Are the meeting minutes provided online?
Yes.
Yes.
So does the appeal rate start?
Within 30 days of
They have to approve.
after we approve our meeting
Okay.
minutes.
Got it. Thank you.
Okay. Again, the next meeting is for March 8th, 2016, to approve these meeting minutes, 7 o'clock on a Tuesday evening.
I want to know what it feels like to be a trustee.
All right. That said, I am going to motion to adjourn.
All in favor?
Aye. We are adjourned.